Welcome to another episode of Real Estate Services and Transactions, otherwise known as REST. This is a subsidiary of Real's Academy. My name is Oluwafemi Sanusi, and I'm so delighted that you are joining us again for another episode. In the house today, we have a seasoned estate surveyor and valuer in the person of ESV Olalekan Aboderin. He is the lead advisor of Olalekan Aboderin Consulting, a real estate and estate surveyors and valuers firm, and also the director of studies of Real's Academy, a real estate training center here in Lagos, Nigeria. Thank you for joining us once again, sir.
It's indeed my pleasure. Thank you.
Yeah, today we're going to be talking about the types and importance of property title. But I want to, before we started this, I was sharing with you on a particular incident. Somebody wanted to sell a property and between two parties. So he sent the deed of assignment. Okay, I'll call them, not their real names, I'll call them Mr. Tunde and Mr. Wale. So Mr. Tunde, the deed of assignment carried the name of Mr. Tunde and Mr. Wale. All right. But when the survey was sent, it carried the name of Mr. Chinedu, which was not part of the names on the deed of assignment. So I was asking you that in that instance, what do you do? That you mentioned that there should be a deed of assignment showing the transaction between Mr. Chinedu and Mr. Tunde for us to go. So I want us to start on that note.
Okay, thank you. That is a question of proper titling. And I think it's simply a situation where there is gap in title. Where there is gap in title, it means there is no nexus, there is no connectivity. The survey is reading Mr. Chinedu, and it means one way or the other, Chinedu must have been of a vested interest in that property. Maybe he has acquired rights in the property before, and that there is a document to which that survey relates. So, but Tunde and Wale on a deed of assignment. Now, there is no connection between Chinedu and Tunde and Wale. So there is need for, well, out of the deed, if there is a deed of assignment in favor of Tunde and Wale, there should be a reciter in that deed that will show how Tunde and Wale acquired, how what constitutes their root of title. That root of title might probably relate to the title of Chinedu. That would then mean that they have acquired the right from Chinedu. But for nexus, it's important that the deed evidencing the interest of Chinedu be produced. And that deed can be in terms of sales agreements, can be in terms of deed of assignment. These are things we'll be discussing today. So that nexus is very, very important. Otherwise, there won't be transferability if there is gap in title.
That gives us an idea that quite a number of people really don't understand what title to property is.
Yeah, that's the essence of this discussion.
So can you just give us a background?
Yeah, talking about title, you see, a lot of people, when they acquire property, they just take possession. And they feel that, oh, I'm there. I mean, nobody is disturbing me. Title is very, very important. Because the word title to land that we are talking about here, we are saying the title that the property has. It's not caption that we are talking about here. It's an instrument. That instrument is the one that will create right in land in favor of the buyer or in favor of whoever is claiming to be the owner. And is the one that is the evidence of the right that the person has. So title to land is very, very important. It's an important element of ownership because it's the one that will show what type of interest the person has and what are the conditions surrounding that right that he has. So it's important to have title to land.
So given that, I want you to, I know that there are different types of titles that we have. So I want you to educate our viewers on that particular point in terms of types of title that we have.
Yes, there are different types of titles. But before we go to types, let's first of all make it clear to our viewers that there are two categories.
Okay.
We have what we call registered title, which is legal title. We have the equitable title, which is, in a plain language, unregistered. when a title has not complied with the statutory requirements,
Okay.
it will be an unregistered title. It will be an equitable title. But when a title complies with statutory requirements, right, then it becomes a legal title.
Okay.
And such statutory requirements is simply that, one, it has to be registered, it has to be witnessed by government.
Okay.
It has to fulfill the provision of statute. There will be proper documentation of that title with government, in government covers, in government registry. And that will require stamp duty and will require registration. Now, it depends on the nature of the transaction. If it's a primary transaction, for example, where there is no root of title, then government will issue the title.
Okay.
But if there have been a root of title, then it will require processing governor's consent. Because that's the provision of the law.
Okay.
That consent must be obtained. So these two processes will make the title to be legal title.
Okay.
But where it is equitable title, it means the buyer, the owner, has title.
Okay.
Deed that is evidencing his interest in land.
Okay.
But that he has not complied with this provision of statute to make it a legal title.
Okay.
Such could be that what he has acquired parcel of land from under native law and custom, from villagers, so to say, Omonile and so on and so forth, where they do not have root of title, and so they have issued either a deed of assignment or a sales agreement in favor of such a person. Such a person requires to now process a legal title in respect of his interest. And that is by making submission to government, applying for issuance of certificate of occupancy, given the provision of Land Use Act, which is the current land regime as we speak. So, but in a situation where the person had bought a parcel of land that has a subsisting legal title, in that case, the compliance with provision of title of statute is to process consents. That consent could be governor's consent and could be minister's consent, depending on where the land situates. If the land situates within the state's territory, it will be governor's consent. If the land situates within federal strip of land that are vested in federal government, it's going to be minister's consent. So that consent is the provision of law. Where that consent is not yet obtained, is an equitable right. The interest vested in the person will still be an equitable interest. So, but in a situation where that consent has been processed, and to complete it, there will be payment for stamp duty and there will be registration of that deed. In fact, the law, registration, the registration law, title registration law requires that the deed must be registered. So, with that deed being registered, it becomes a legal title. So those are the two categories. Where is a legal title, the record will be with government. It will have complied with the provision of statute. But where it is an equitable interest, the owner will have the documents, but the document is still with him without complying with the provision of statute. And if he has not complied with the provision of statute, he won't be able to register it with land registry, and hence it will not be a legal title. So that is talking about the categories of title that we have. Now, in terms of types, we now have, well, as I've said, we have anything deed that relates to maybe deed of conveyance, sales agreements, deed of assignment, deed of sublease. All these, if they are not registered, they will come under the category of equitable title. But where you have registered deed of conveyance, you have registered deed of assignments, you have land certificates. Land certificate is issued by government. You have certificate of occupancy, is issued by government. You can equally have, right of occupancy in respect of rural land, so to say, under the provision of Land Use Act. All these are types of title under legal title. They are the different categories of title that we have. Now, equally, there could be a case where there is an existing CFO
Okay.
or a existing registered title, there could be a case where the buyer will only procure what we call power of attorney.
All right.
Power of attorney can actually convey, creates right in land, can convey interest in land in favor of the attorney.
Okay.
Right? You can convey that in favor of the donee.
Okay.
Because the donor, if it is for it to create right in land, it must be an irrevocable power of attorney.
Okay.
And there must be consideration for that power of attorney to be donated. And the rights and obligations that the donor has will now be, through that donation, through the power of attorney, will now be transferred in favor of the donee.
Okay.
So such can equally be registered, and it will now put that donee in position of the donor to exercise all power and all rights that the donor has, just as it's going to equally be liable for all obligations. So these are the types of, and that power of attorney can equally be registered. Okay. Yeah, it's supposed to be registered. Okay. Because before you can become a legal, convey a legal interest.
Okay. Okay. Yes. So coming in before we came in today, I think I asked you a question that because I was asking that based on things I've heard, that is survey and receipt a title?
Okay, that is, well, the answer is simple. Survey and receipts are not title. Okay. Survey is a document required for property titling. Okay. But on its own, it's not a title. Okay. Because on the face of it, it does not have the capacity to create right in land. If we analyze the concept of right in land, survey does not have capacity to create right in land. And equally, it does not fulfill the requirement of a deed. Okay. And the law requires that land transaction, particularly when you are buying like this or you use a long lease, it's supposed to be with deed. So survey on its own is not a title, but it's a necessary input in land titling. Okay. It's a necessary requirement to have land title. Okay. And it's because survey is the one that would delineate excuse me, the land holding that is to be titled. Okay. It will delineate the land holding that is to be titled. That is just the plain thing. That's the purpose of the survey. So with that delineation, then it makes it possible for us to identify what is the land units that constitute the proprietary land units. Okay. So that is what the survey does. But as a document on its own, it is not a title. I am aware that a lot of people, display survey and receipt as a title. It happens when you want to buy from people that have bought from Omonile or even from Omonile. Okay. But if Omonile will issue you receipt and you have processed preparation of land surveying, that is the survey plan, why don't you get a deed from the same family so that you have a proper title? So this is very, very important for us to know. And in terms of receipt is evidence of payment. On its own too, it does not fulfill the requirements of being a title because if we analyze the feature of a deed, you say that receipt is lacking in some of these features. Now, and I think in Nigeria there have been a well-celebrated case about receipt, being a title or not being a title. Okay. And the position is that receipt is not a title. Okay. Yeah. So it's an evidence of transaction, evidence of payment. I would say that receipt will create privity of contract. Okay. That there have been a contract between both parties. Between two parties. But in lands, contracts, when it has to do with purchase of land, it goes beyond privity of contract. There should equally be privity of estate. Interest in land must be created by somebody in favor of another person. So two parties now having a relationship in terms of estate.
Okay.
Two parties having relationship in terms of estate, the grantor and the grantee, and what form of right has been created. Privity of estate.
Okay.
And this you receive does not have that capacity.
Okay. Okay. So viewers, you see that it's very, very important for you to know that survey and receipt, they are not registered or titles as we know. So moving on, sir. I want you to shed more light on this, that maybe an individual wants to purchase a property that already has a C of O. Does he need to do any further titling?
Yes, he has to do titling, but not to process another C of O.
Okay.
Okay. So let's get that clear.
Okay.
He has to do titling because, you see, land administration requires, okay, for example, if he had bought he has bought a property that has C of O. Okay. That property already has a legal title. That right is now assigned to him. Okay. When that right is assigned to him, okay, if he has not processed governor's consent, he will be having an equitable interest. Okay. He will be having an equitable title. He will not have a legal title. Because for him to have a legal title, he has to comply with the provision of the law. Okay. And the law says the consent of the governor or the minister, as the case may be, must be obtained. Okay. Actually, the provision of the law is that it's a power of consent. It's a consent that must be obtained for that alienation. Okay. So, but, well, in practice, what we see is that that body is transferred to the buyer. Okay. And of course, it's the buyer that will actually want to have a secured title. Okay. So buyer always want to have, to bear that burden. But again, that clause must always be cited in the deed that is created in favor of the buyer. So the buyer will need to process title, and that is by processing governor's consent and deed registration. Okay. Yes. Okay. So with governor's consent, when it is endorsed, there will be other processes in terms of stamp duty, and it has to be registered. At that point, it becomes vested with the unexpired residue of interest in that C of O. If it's an assignment, if it's an assignment, it will have the unexpired residue of the interest that the holder of that C of O has. So it will not need to process another C of O at all. And that will suffice against having another C of O. As a matter of fact, in deed registry, what will happen is that they will have charged that C of O and charge that deed of assignment against the C of O in their record. So, and automatically, whatever the C of O, the right it conveys will now be vested in the order of the registered deed of assignment.
I mean, we are really running out of time, but I think we're going to bring you back again to dwell more on this issue of titling.
Yeah, it's really very important because title is everything about land. Very, very important. Without title, I mean, you have bought nothing.
That's correct. So viewers, I believe we've been informed about what title is, and we believe that you will consult your professionals whenever you want to purchase your property. So with that, we've come to the end of this episode of Real Estate Services and Transaction. Until next time, please continue to stay safe. My name is Oluwafemi Sanusi. Bye-bye.